Hello, everyone. Welcome to our channel, Legal Notions. I hope that you have enjoyed our previous two videos. The first one being on the force majeure clause, the second one on right to privacy and public health. And today's topic here is again with respect to coronavirus 2019, but specifically with respect to patent law. So the topic that we have chosen for today's discussion is the operation of patent law during COVID-19. So here we have with us Rohan Jacob and I, Manoj Raiko. We'll be discussing specifically on this topic that we have chosen today. So let's begin with a basic information as to what the patent law prescribes about medicine in general. So Rohan, if you can start off with that.
Yeah, so basically, what brought us to this topic was the fact that this organization called the Cancer Patients Aid Association, had written a letter to the government asking the government to revoke a patent granted to the drug remdesivir. Now, the unique thing about remdesivir is that the WHO lists it as the most hopeful medicine in finding a cure towards coronavirus, among two other HIV drugs, which are, if I'm not wrong, libenavir and ritonavir. Um, Now, the fact is, this patent was granted in Feb 2020, and the issue that the letter specifies two particular issues. Firstly, that the drug is merely a reformulation of an already existing published formula, and because of that, it should not be granted a patent. The other aspect is that under the Patents Act, under Section 66 of the Act, the central government has the power to revoke a patent that has been granted in the light of public interest, where the exercise or the exploitation of the patent would be prejudicial to a public interest. So, what we essentially thought of was how do we balance the amount or the level of investment that goes into finding a cure for such epidemics and pandemics as a point for future scenarios, and how do we balance that vis-a-vis the need to grant access to these medicines, which are then protected by patents. um, Initially, I would just say, Manoj, do you think that we satisfy this? Firstly, I mean, do you think that the Patent Act is not strong enough that we would have to grant or ask for revocation, and therefore, in satisfy the instances or the preconditions for granting a revocation?
So I think patent law makes it amply clear with respect to the requirement, the reason for why patents are granted to these pharmaceutical industries for these generic drugs, primarily to protect the interests of these pharmaceutical industries in terms of R&D for future developments. They have invested their financial resources in developing these drugs, and granting of patents is in a way to protect to make sure that whatever financial burden that they have borne is recouped in the sales of these drugs. But then again, we have certain provisions in the Patent Act itself, which provides for solutions in situations such as the one that is created by COVID-19. For instance, we have the compulsory licensing under Section 84 of the Patents Act, which clearly provides for three grounds which are in isolation of each other. The first being that compulsory licensing can be requested before the patents officer, on first ground being the patentee is unable to satisfy reasonable requirements of the public. Now, this ground is the most suitable grounds amongst the other two. That is, the second one being that the patentee has not made the product available at a reasonably affordable price. And the last one being the patented innovation is not worked in India. So, if you were to consider these three grounds for grant of compulsory license, I think the important one is the first one. That is, the patentee is unable to satisfy reasonable requirements of the public. Given the situation that has been created by COVID-19, it's tantamount that there is a widespread requirement of supply of these drugs, and these drugs need to be supplied immediately and at a greater quantity and at a higher frequency than any other drug that is in the market currently. So I think, as against the second ground, that is pricing it reasonably, there is no uh, uh, assumptions or approximations that can be derived at this point of arrived at this point of time as to at what prices would these drugs be sold in India. So therefore, it is reasonable to assume that compulsory licensing under the first ground, that it the patentee is not able to meet the reasonable requirements, would be the sufficient ground for granting compulsory license by the patent officer. And this I think is a prominent way to deal with the situation currently that we are in, with which brings the patent law, which brings the operation of patent law within the ambit of COVID-19 situation. And if I may continue on the base of this, do you think are there any other remedies that Patent Act prescribes on this front?
Right. Actually, one point you did bring up is, how do we evaluate the need, or that the requirements for a compulsory license, or CL for short, are met before we actually see the patent being exploited, right? How do we say that the patentee is not producing a sufficient quantity or is setting too high a price? So my my issue with granting a CL right at the very beginning is that when we're not exactly giving a proper evaluation to these factors before we engage in a compulsory license procedure. But coming to your other point, there are other aspects which allow, or at least allow for such situations. Firstly is Section 92, which allows the central government to authorize either itself or any other person to utilize the patent in situations of national emergency or extreme circumstances or urgent circumstances. And what this then does, the Section 92 actually is a go around to the 3-year requirement as specified under Section 84. And quite clearly, I mean, COVID-19 is a situation of national emergency, and this is something that the central government can absolutely resort to. Another provision that the government can rely on is on Section 100, whereby, just if I may refer you to it, Section 100 allows the central government, especially with regard to the patent that it has just granted, uh, to to specifically use the invention for the purposes of the government, right? This is merely an extension of Section 92, but this specifically allows, without any requirement of remuneration or royalty to the patentee, to immediately utilize the patent that it has so granted. And Section 100 is actually referred to as Marchant rights of the government, allows the government to utilize any patent or utilize the invention that it there grants a patent for the purposes of the government, right? And then another extension on that is Section 102, which allows the government to acquire not only the invention but also multiplications of that particular invention. So any stockpile of drugs that are made with regard to, let's say, remdesivir in this present case, those stockpiles can then be acquired by the government to be put to that use. Um, but now, I mean, this brings us to the larger question: the fact that not only are we presuming that the situations for compulsory licensing have arisen, but we are at a very preliminary stage, taking away the chance for any patentee to recoup whatever investment he has made. Um, which also, I mean, at least compulsory licensing to some extent, at least under Section 84 and 92, allows for a royalty to be paid, as well as under 103, that the High Court may determine such royalty. But when we look at revocation, it's a lot stronger, in the sense that you are denying a patent already being granted. And the basic subset of a compulsory licensing agreement is that there is an underlying patent. So when we revoke the grant of a patent, we are stripping them of the right to earn royalty as well, either through a compulsory license or even a voluntary license. Which then brings me to my ultimate question. I see a bit of, if we start to say that Section 66 is satisfied with regard to public interest, then I have a doubt, because when we come to Section 3, if you look at Section 3B, which talks about what is patentable and what is not patent, specifically what is not patentable inventions. If you look at 3B, it specifies that an invention, the primary or intended use or commercial exploitation of which would be contrary to public order, morality, or which causes serious prejudice to human health. Now, do such situations allow us, if we're looking at revocation as an option, should that not also allow us an opportunity to hold that such inventions, the commercial exploitation of which would be prejudicial to human health? Um, is that something we should consider, or should we just completely prevent the application of Section 3B in such cases? Over to you, Manoj.
Uh, yeah, thank you, Rohan. I think revocation under Section 66, there is a set of parameters that needs to be looked into. One such parameter, if I highlight, is that the patent itself or its mode of exercise is mischievous to the state. So, in the sense, there has to be not just public interest that needs to be fulfilled under Section 66 for purpose of revocation of patent. The patent holder has to apply the patent in such a way or make utilize or of the patent that is granted to him, which is contrary or is mischievous to the state. So only under those situations can you revoke a patent under Section 66. So revocation of patent under Section
or
6. Yeah, you have any?
or it could also be prejudicial to the public, right? I
Yeah,
mean, that's the third part.
indeed. It has to be it can be prejudicial to the interest of the public at large. But then again, you will have to determine how is it being prejudiced to the public interest at large. First of all, you need to have a drug that needs to be supplied to the public at large, and then on what basis are you determining that it is being prejudicial to the public at large? It first could be in terms of the quantity. First, it could be in terms of the pricing. If it is charged excessively than what could have been reasonably afforded by the public at large. In those situations, can you say that the public interest is being prejudiced, and only then can you revoke a patent under Section 66. But however, there are certain instances where the courts have taken due effect to the public interest at large while deciding the cases. And one such case is a Delhi High Court decision in Merck versus Glenmark, wherein the Delhi High Court cited public interest as a significant factor for the purpose of granting an injunction for the purpose of granting an injunction in that case. Similarly, even in Roach versus Cipla, wherein public interest and significant price difference in the drugs that were being sold, demanded that an interim injunction not be granted, which was requested by one of the parties, wherein the other party had a patent in its was a patent holder. So in these situations, what can be noticed is that even the judiciary has been at the forefront in interpreting the needs of the public at large. So citing public interest as a major reason, and relying on the provisions, excerpts of the provisions that are there in the Patent Act, the courts have been in favor of granting injunction, or for that matter, not granting an injunction. So considering the margin rights, the compulsory licensing, even to bypass the 3-year exception period under circumstances of extreme emergency under Section 92, I think it's possible, given the situation, that the patent uh, the patent that has been granted to the patent holder could be subjected to compulsory licensing. I think compulsory licensing would be a more suitable option at this point of time than to look at any other than to look at any other possible remedy in this situation. And unless you have a contrary opinion on that.
No, I quite I agree with you on a pretty strong point, because even if you look at the international law on this, the Doha Declaration was primarily what came out as an addendum to the TRIPS agreement, and it focused primarily on the aspect of public health issues for developing and least developed countries, right? And I went through the Doha Declaration, and they only, while they are vague in terms of the fact that they say member states are free to formulate their own mechanisms to tackle public health issues, they do consistently reinforce compulsory licensing as a means to tackle public health issues. And nowhere is it even discussed that revocation of a patent is a viable option to be exercised. And so when we look at the trips and we look at the Doha Declaration, it's quite obvious that uh, on an international scale, we've looked at it only from the perspective of compulsory licensing. So we still want the patent holder to hold on to the patent and also be granted recognition for it. But we also allow for these licenses to be given so as to ensure that there's sufficient production of the drug and there's sufficient access to it, right? And at the same time, there's a royalty that's being given to the patent holder. So in that sense, I mean, I guess despite the fact that section 66 and, as I pointed out, section 3b differ in terms of what they mean to be, as since 66 talks about prejudicial to the public, whereas 3b talks about commercial exploitation being prejudicial to human health. Even though they have different phrasings and in essence they may mean the same, I would say the intention therefore is that we cannot rely on either of these sections as a means to ensure that there's public access to the drug. Interestingly, however, there seems to be a movement by a lot of companies in the pharmaceutical sector as well as in other sectors to waive their rights over the particular drug that they have a patent for. A lot of companies, I believe, there is a company which produces a particular drug for, I think, HIV, and that particular company has chosen to waive its rights over that drug. I'm forgetting the name of it, but all over there have been instances where companies have been waiving their rights due to overwhelming public pressure in order to avoid such adverse implications to their reputation. So on a public on a private front, I would say companies seem to be opting for these routes under 3b and revocation, in the sense that they're not exercising their patents. But as far as the patent law goes, it seems to be strong enough that there are sufficient provisions for the government to resort to in order to ensure public access. Another point that I wanted to bring up is that if we do allow, because I believe in 2016 in an India US Business Council meet, uh, Indian representatives had made an oral representation to the US counterparts, where they said that they would not grant any future compulsory licenses. Now, this has always been the fundamental question when it comes to access to public health vis-a-vis patents. But how do we allow, or how do we ensure that these companies or specifically big pharma, who regularly fights or pursues litigation to ensure that they recoup their investment and they capture the larger part of their profits, um, how do we ensure that there's no backlash from these companies when it comes to, say, international trade or any other aspects? Over to you, Manoj.
Uh, yeah, I think what we need to see, like you rightly pointed out, is an international, even in the international perspective and as well as a domestic perspective, is the significance of not significance of revoking the patent rights, right, over these drugs which are helpful for the public at large. So, irrespective of the international trade or the domestic implications that it might have, I think it's important. I think the Patent Act in itself provides enough legal basis for us to circumvent the issue created by coronavirus 2019. I think if I can summarize the entire Patent Act into five important aspects that we have discussed throughout our video, throughout our discussion. The first one being the first possible ground on which the patent could be uh, challenged is directly challenging the patent for lack of innovation or lack of utility or any such ground that a challenge can be brought before the court. This is the first ground on which a drug which cures coronavirus could be challenged. But however, on the very face of it, it doesn't seem like challenge will stand. And the second one would be compulsory licensing under Section 84 of the Patent Act before the patent officer. If primarily it is only after 3 years can you file for a compulsory licensing, but however an exception is created under Section 92 for circumstances of extreme emergency or national emergency. And and the grounds for these compulsory licensing are as discussed previously. One is the patentee is unable to satisfy the reasonable requirements of the public. Second, the patentee has not made the product available at reasonably affordable price. And lastly, the patented innovation is not worked in India. And coming to a next possible solution that we discussed is a margin rights of the government under Section 100, wherein it provides a right to government to intervene in the interest of the public at large, uh, or to, by paying sufficient remuneration to the patent holder to take over the patent rights. And the next one is obviously the revocation that we have discussed at large. Revocation under Section 66, read with Section 3B of the Patent Act. And last but not the least is a judicial precedents that have been set in the context of patent law, wherein the judiciary has emphasized the need of a public interest as a significant factor to be considering while applying the provisions of the patent law. So, therefore, I it seems to me that there is sufficient provisions, sufficient law grounds for protecting the patent holder, as well as at the same time fulfilling the obligations of the government with respect to the public at large. If you have any more additions to make to this submission, Jacob. Hello, Jacob. Rohan. Yeah, coming back from the technical glitch again. Rohan, if you have anything to add.
Yeah, so just to take off on a different note now, um, what happens therefore if we, I mean, in two situations, I mean, there are two questions now. One is that if we do grant a revocation of a patent, does that subsequently bar the same patentee from filing for another patent afterwards, after the situation, after COVID-19 is no longer uh, a natural disaster or an epidemic, or termed in the eyes of law as such, right? Does it then bar him from applying for a new patent on for the same drug on those grounds, given the fact that prior publication is seen to be a limitation to the grant of a patent, right? On this, I mean, this is not a situation that possibly has come up, but if you look at Section 29, the provision seems to be wide enough to allow the fact that, or it specifies that where the prior publication has been made through a provisional specification, or a prior publication has been made by the patentee himself, then it does not, then the invention is not anticipated by such publication. So by going by that logic, uh, I would then say that in those circumstances, if we do grant a revocation, then the patentee does have uh, the right to file for a new patent, and get a new patent granted, but not being blocked by prior publication. I'd like to hear your views on that. But before I do, I want to give you the other question as well. Is the fact is that compulsory licenses can also be revoked, right? And this can be done after the situation that gives cause for a compulsory license to be granted. That after that situation has passed, the controller can then revoke the compulsory license so granted. And now, considering that we're not only looking at a cure, but we're also looking at a COVID-19 vaccine, right? And that vaccine is ideally going to be utilized for future generations to come. Um, do we only apply whatever we've discussed specifically to a COVID-19 cure, and not a COVID-19 vaccine, such that because of the fact that the COVID-19 vaccine is going to be utilized much after the pandemic situation, merely as a preventive measure, do we then only, as we've discussed, to ensure larger access, keep it only to the cure and not to the vaccine? So your views on both these points.
Yeah, coming to the first point, that is after the coronavirus situation ceases to exist, do we grant the publication, the
New patent, yeah.
new patent? So I think granting of new patent then becomes redundant, right? So let's say the very reason why you grant patent is to seal any other competitor in the market copying the product that you have and sell it at a lower price, because the cost that he incurs after the invention has already been made would be much lesser, because he just has to reverse engineer the entire process of making the product. So that is provided under the Patents Act under Section 107A, which is the BOLAR exemption. That is for generic drugs. Now, coming to your question of granting new patent, I don't see how it uh, comes to achieve any further goal if in fact is if there is any goal. Now, the very reason why you grant these patents is to make sure the finances that is been the expenditure that has been incurred by these companies during the manufacture of these products. But so my entire question is, it doesn't there's no question of granting new patent anymore, right? So the reason for the granting of new patent doesn't exist anymore. Even if you grant the initial inventor of that particular drug the patent, there are other competitors who already know how to manufacture the drug and will go ahead manufacturing the drug. How will you stop them from claiming? Uh, how will you stop
That's
them?
exactly the point, right? Would you allow the original patentee to recoup his investments by granting him a new patent and excluding all these other competitors who already know how the drug is produced, and thereby blocking their access into the market?
Uh, that's in fact possible, but then again, your whole reason for the grant of patent, I think, ceases to exist. So that is my first point of view. And coming to compulsory licensing, uh, yeah, it is possible for revocation of this compulsory licensing, and I think that's a possible solution uh, if you combine both the first issue and the second issue, like granting of a new patent and the revocation of compulsory
Um, I was specifically talking about, do we apply compulsory licensing only to the cure and not the vaccine, because the vaccine is going to be used even after the situation ceases to exist.
I think, yeah, I think cure, the first compulsory licensing is only for the cure purposes. And once it is cured, you can revoke the compulsory licensing for the vaccination purposes. In the sense, there can be a special patent that is granted for the new vaccine that is developed, that is for the future use. So I think in this respect, the compulsory licensing can be of two different aspects involving two different things. The first part being, like you mentioned, the cure part, and the second one being the vaccine to to prevent the patient being succumbing to COVID coronavirus. And I think with this, we have substantially covered the important aspects of the operation of patent law during COVID-19. Unless you have anything to add.
I just have a final note, I guess, is that if we look at also 92A, 92A is a mechanism whereby least developed countries can apply to the Indian Controller General for a compulsory license in order to export any drug that is so required by them. I feel, again, I feel that if we go for revocation also prevents least developed countries from accessing these patents, because since the underlying patent is revoked, there's no scope for them to apply for a compulsory license for export of that particular drug. So I guess in conclusion, as we've come to now, revocation as well as refusing to grant a patent is not, firstly, it's not something that international law has contemplated as a resort to, and secondly, it does not hold good for the stakeholders to engage in revocation of any patent that has been granted. So I see at this juncture, I guess I see the letter that the CPA has sent to the ministry would ultimately fail in what they seek to achieve. Any concluding points?
Yeah, I think we have discussed on all the points of law that we needed to discuss. And I leave it to our viewers to add any extra points that they want to add in the comment section below. Or if you want to open up the forum for discussion on any points that we have left out, please do contact us uh, through the Instagram DMs, or you can contact either of us directly, so that we can have further discussions on the very point of law that we have missed out in our discussions. So
I
with
concur.
this, I conclude today's discussion on the point of the operation of patent law during COVID-19 situation. And I thank Rohan for your valuable time. And yeah, thank you guys. I hope you like the video. Please like, share, and subscribe, and hit the bell icon. Thank you.